My name is Judy Perry Martinez, and I'm a vice president at the World Justice Project. And I join you here today as we present the World Justice Project's 2025 Rule of Law Award to an extraordinary rule of law champion who truly exemplifies the spirit of this year's forum, standing up for the rule of law. The World Justice Project has presented the Rule of Law Award since 2011 to honor individuals or organizations. Notably, in 2019, this award recognized current Polish Minister of Justice, Adam Bodnar, who was serving at the time as Poland's ombudsman for human rights. During that time, Minister Bodnar and his staff at the Human Rights Commission were engaged in outspoken defense and strategic litigation to protect Poland's constitutional principles. These years later, it is fitting that we find ourselves in Warsaw to reiterate essential values of constitutionalism, ethical governance, and fundamental rights. This year's Rule of Law Award honoree exemplifies a tireless commitment to those principles, and above all, a lifelong dedication to justice. On behalf of the World Justice Project, it is my great honor to present the 2025 Rule of Law Award to the former Chief Justice of South Africa's Constitutional Court, the Honorable Raymond Zondo. In presenting this award, we recognize Chief Justice Zondo's exceptional legal career spanning decades of public service and his courageous achievements upholding judicial integrity and enforcing accountability for public officials. He has underscored in both word and deed that the rule of law is the foundation of South Africa's democracy, and that no individual, no matter how powerful, is above the law. In doing so, he has been an example to rule of law defenders around the world. In the course of his career, Chief Justice Zondo has authored over 200 judgments, reformed public institutions, and made lasting legal impact for millions of South Africans. He joined the Constitutional Court in 2012, and in that same year handed down a landmark judgment preventing extradition to countries with death penalties, declaring that South Africa's constitutional protection of human dignity and life extends to all persons within its borders, regardless of citizenship. In his tenure as Chief Justice, he actively worked to institutionalize judicial independence and improve the justice system. He led efforts to restore public confidence in the Judicial Service Commission, the body that selects judges, ensuring that its processes and procedures were fair and merit-based. He also championed financial independence for the judiciary so that courts would have adequate resources free from political interference. These reforms strengthened the judiciary as a co-equal branch of government. But perhaps his most celebrated contribution to the rule of law is his role as chair of the Commission of Inquiry into Allegations of State Capture, also known as the Zondo Commission. He was entrusted with this inquiry in 2018 at a time when South Africa was reeling from allegations of massive corruption. He led the commission with unwavering diligence and integrity, despite immense political pressure and public scrutiny. Under Chief Justice Zondo's stewardship, the Commission undertook an exhaustive investigation into corruption in the public sector. Over 400 days of hearings, the Commission heard testimony from over 300 witnesses and reviewed more than 1.7 million pages of documentary evidence. The proceedings were broadcast live, educating the public on the extent of wrongdoing and reinforcing the principle that those in power must answer to the people. The final reports of the Zondo Commission were delivered in 2022 and have been hailed as a roadmap for national reform. Thanks to his leadership, South Africa has begun pursuing those implicated in introducing new laws, such as a strengthened Public Procurement Act, to ensure that the era of state capture is never repeated. In honoring Chief Justice Zondo with this award, we recognize not only his individual milestones, the titles he has held, and the inquiries he has led, but also the enduring legacy of his integrity and public trust he leaves behind. He reminds all of us and all those who are committed judiciary that the judiciary can indeed safeguard fundamental rights and push back on authoritarian influence. I would like to now pass the floor to Minister Bodnar to share his own brief remarks and reflections on the meaning of this award, which he has received, and the significance of Chief Justice Zondo's achievements.
Dear Mr. Chief Justice, dear Judy, ladies and gentlemen, it is my great privilege and honor to be here with you in this capacity. I remember this beautiful day in The Hague when I, together with the Office Ombudsman, were the recipients of the World Justice Prize or Justice Award. It was really remarkable thing to be appreciated for the fight for the rule of law, for the fight for the human rights and constitutional justice. But I would like to say a few words regarding this special award and this special connection between Poland and South Africa. So, because when I read the story of life of Chief Justice Zondo, I see that there are so many parallel issues that should be taken into account in this regard. I remember well that when we are getting through the moment of period of transformation in Poland in the 90s, I remember that South Africa was inspiration to us, but my feeling is that it also worked vice versa. Scholars name this period as so-called third wave of constitutionalism. That in the 90s, after different difficult periods of history in this part of the world, it was the period of communism. In South Africa, it was apartheid. We are getting through, and we are opening new lives with the new constitutionalism. And there was a strong belief at that time, shaped by a number of intellectuals, but also international scholars, constitutional scholars, that the only solution for our countries is basically shaping our agenda on the basis of human rights and the respect for civil liberties, and on the basis of the rule of law, with very important and strong institutional actors that are protecting those values. And I remember, because some of my mentors at that time were very much engaged into shaping this agenda, and one of them was Professor Wiktor Osiatyński, who has written a lot of books on constitutionalism, human rights. He was affiliated with the University of Chicago, with a number of other universities. Then he was mostly in Warsaw. But I remember that he cherished the development in South Africa. And I remember that once, even, I don't remember exactly when was it, I think it was more or less 2000, 2001, that he even brought Richard Goldstone to Poland to deliver a lecture, to present, listen, that is the example of South African constitutional court, and basically they are talking with the same values, with the same principles, with the same interpretation as we are talking here in Poland regarding our constitution. I remember that, and even if you look into the Polish constitution and South African constitution, it is very much similar in terms of how it is shaped. It is similar in terms of reference to dignity. It is similar in terms of so-called limitations clause in the constitution, respect for civil liberties, and also the need of enforcing social rights, but in a way how social rights interact with the question of dignity. And for mostly, of course, they are very much the same regarding the question of equality that were in the constitution. And if you look back into 90s, you see that this development and shaping of the understanding of the constitutionalism in our countries, and not only in our countries, but in general in this part of the world, was very much similar and based on similar values. To be honest, right now, when I see that Chief Justice has led the Constitutional Court for so many years, to be honest, I'm quite jealous, because right now in Poland we do not have the same experience. Okay, when I have read that you have delivered altogether 57 judgments as a judge, rapporteur for all those years in the court, first serving as a regular judge, then deputy chief justice, then at the end for 2 years as the chief justice. I really envy you that you could make it happen. And I think, and one of the judgments was mentioned already, the judgment about the prohibition of extradition to country where the death penalty is practiced. But I think sometime yesterday we had a brief conversation, and naturally Judge Zondo, Chief Justice Zondo, mentioned his favorite topic, which is the labor rights cases and his contribution to the daily living of people, because that is the practice that led him to this position of the Justice of the Constitutional Court and later on Chief Justice. But I think that you should be interested that this person in front of you has also delivered a 2018 judgment saying that right to cultivate and use cannabis for private use is a right to privacy, which is quite an important development from the point of view of constitutionalism. And we know that that kind of a development was not, let's say, made in number of countries, and there is ongoing discussion in number of countries how to approach the use of cannabis for private purposes. But surely we are not here because of this judgment. We are not here because of number of other judgments. But we are here because there was a very special task that has been entrusted to Chief Justice Zondo. So in January 2018, the President Zuma appointed Justice Zondo as the chair of the Commission of Inquiry into State Capture, Corruption and Fraud in the Public Sector. And as it has been said, there were 300 witnesses interrogated by this commission, 400 session days, almost 160,000 pages of evidence collected. And basically this collection created an example that if you are dealing with a massive fraud, corruption, abuse of state power, as it has been named state capture, you cannot use just traditional means. You need extraordinary means, because in order to identify all those traces, all those problems, and give recommendations to state authorities how to get out those problems, you need two things. You need passion and hard work, and basically in terms of those numbers, we see that it has been done, that you cannot achieve a really substantial change by just declaring that you are going to do something. You really need to spend time on this. And second, you need individuals with the highest level of professionalism and integrity. And that is something for what we would like to, World Justice Project would like to appreciate you, that this high level of professionalism and integrity is a reminder to all of us that success of that kind of institutions, that kind of endeavors, that kind of non-typical institutions, to great extent depends on individuals, and it is not just a question that you will passing, this law, this resolution, or whatever in the context of establishing this or the other commission. And when I see it, I see in this not only your personal achievement, but I see that you are building on giants, on, of course, Nelson Mandela, on Desmond Tutu, but also on those lawyers whom I have even privileged to know some of them. I mean, especially Katie O'Regan, one of the long-serving justices of the Constitutional Court of South Africa, one of your first mentors, Richard Goldstone, with whom you worked in one of those committees investigating abuses in 90s, but also Victoria Mzenge, who was activist murdered by the apartheid regime in Durban. So if you have that kind of a legacy of working with all those people, then you are strong enough to continue. You have, I will tell you that one of my greatest books on law I have read was the book by Albie Sachs, also one of the justices of the Constitutional Court of South Africa. Very interesting book, A Strange Alchemy Between Law and Life. So the book in which he's describing some of those judgments, and maybe you should do the same, in fact, describe not only those two judgments we have already mentioned, but some other. But it is a very special book in which he's explaining not only the content of judgments, but basically what was the political, social atmosphere leading towards those judgments. Why the Constitutional Court was dealing with homelessness, why the court was dealing with special issues of access to water, or cases concerning same-sex registered partnerships. All different cases that transform, I think, the constitutional landscape of South Africa. So my point is that if you have people who created this imaginary of the constitutionalism in South Africa and globally, and then you are entrusted with the task of making a commission which looks at the beginning as one of the most difficult jobs in the world, thanks to the fact that you have this support from our teachers, and you have your personal integrity and professionalism, then you may achieve the success and really change the mindset and thinking about the abuse of power and create a model how to fight effectively with the corruption. So I would like to congratulate you, and once again I would like to appreciate that I was invited to be in this role to say those few words just exactly to you. Thank you very much.
Thank you, Minister Bodnar. Those remarks were, I know, at a personal level for the Chief Justice, your having received the award in the past. It is now my great privilege on behalf of the World Justice Project to present the 2025 Rule of Law Award to Chief Justice Raymond Zondo. Please come up. Thank you.
Thank you very much, Vice President, for those very nice words just immediately before you gave me the award, but also much earlier when you shared with all present here the motivations as to why the World Justice Project decided to select me as the 2025 Rule of Law Award recipient. May I also take the opportunity to thank the Minister of Justice for his very kind words too about me a few minutes ago. I really appreciate it. Good evening. Good evening. Is it evening? Good afternoon. Let me begin by thanking the World Justice Project for welcoming me and my wife so nicely, so pleasantly when we arrived yesterday. Let me also express my gratitude and appreciation for the dinner that was hosted by the Ministry of Justice last night. Everybody has been very pleasant, very welcoming, very warm to us. I thought that I should just start by making sure that you know that my wife and I, really appreciate how well we have been received and treated here in Warsaw. Leadership of the World Justice Project, Minister of Justice of Poland, Her Excellency, the Ambassador of South Africa in Poland, Ms. Mngomezulu, my dear wife, who is with me here, distinguished guests, ladies and gentlemen. It is for me a great honor and privilege to have been invited to this very important gathering under the theme, Standing Up for the Rule of Law. It is even a singular honor that the World Justice Project selected me as the 2025 recipient of the Rule of Law Award. It is with both a sense of humility and great appreciation that I accept the 2025 Rule of Law Award. I thank the leadership of the World Justice Project and the committee that selected me for this award. It feels great to join the list of distinguished upholders of and fighters for the rule of law who are past recipients of the Rule of Law Award, such as the late President of the US, President Jimmy Carter, Rede Wayuri of the Indigenous Communications Network, Poland's Minister of Justice, and the Nobel Peace Prize laureate Shirin Ebadi. In its letter to me, in which the World Justice Project informed me of the good news of my selection for this award, it said that through my leadership of the State Capture Commission, I had courageously exposed systemic corruption, setting a new standard for accountability in public life. It also said that as Chief Justice, I had championed judicial independence, spearheaded reforms to enhance efficiency and advance gender representation within the judiciary. The theme of this conference is Standing Up for the Rule of Law. The organizers of this conference could not have chosen a more appropriate theme for a gathering such as this one, in which a few minutes ago I was awarded this year's Rule of Law Award. In the context of the theme of this conference, I thought that the question arises for me whether the judiciary of South Africa has stood up for the rule of law. Let me start off by making the point that in the Constitution of South Africa, the rule of law is mentioned in the first section of the Constitution. That shows the place the drafters of our Constitution wanted the rule of law to occupy in our constitutional democracy. The second point to make is that the rule of law is mentioned in Section 1 together with the supremacy of the Constitution as some of the foundational values upon which the South African state is founded. In addition, Section 2 of our Constitution emphasizes the supremacy of the Constitution and proclaims that any law or conduct inconsistent with the Constitution is invalid, and obligations imposed by the Constitution must be fulfilled. This is the context in which the judiciary of South Africa, led by the Constitutional Court of South Africa, has performed its function to uphold the Constitution, to promote and to protect the human rights entrenched in it, and to ensure that the rule of law is observed. I'm able to say without any fear of contradiction that the judiciary of South Africa has, over the past 30 years since the advent of democracy in our country, stood up for the rule of law. Last Friday, South Africa celebrated 30 years of the existence of the Constitutional Court. With the limited time I have, I can only share with you a few cases where the judiciary of South Africa has stood up to be counted in the protection, promotion, and defense of the rule of law. The first one I want to share with you is a case referred to in South Africa generally as the Nkandla judgment, where the public protector had found that a sitting president, that is president of the country, and his family had unduly benefited from the taxpayers' money that government officials had used to effect non-security improvements to his private home. The public protector had effectively ordered that the president should repay a certain percentage of the public funds. She had ordered Parliament to hold the president to account, but Parliament shirked its responsibility and exonerated the president. The matter had to be taken to the Constitutional Court because the president had also ignored the instruction of the public protector. In its judgment, the Constitutional Court was scathing not only on the president, but also on Parliament for failing in its constitutional obligation to hold the president to account. Subsequently, the president did refund a certain percentage of the taxpayers' money after being ordered by the Constitutional Court to do so. In its judgment, the Constitutional Court emphasized the importance of the rule of law, transparency, and accountability. Another case relates to the former president of Sudan, President al-Bashir. He visited South Africa at a time when the International Criminal Court wanted him for various crimes. He came to attend the AU meeting, an AU meeting of heads of state and government in South Africa. At that time, South Africa was a signatory, as it still is, to the Rome Statute, which South Africa had domesticated. Therefore, South Africa had agreed to arrest anyone wanted by International Criminal Court of Justice, the International Criminal Court, and hand him over to that court. However, the executive and leaders of the ruling party began to come up with excuses when the issue arose as to whether South Africa would honor its obligations in terms of the Rome Statute and arrest President al-Bashir when he came to attend the AU meeting. They began to say, you can't arrest a sitting head of state because in doing so you would be declaring a war on his country. It was as if when they signed the Rome Statute and committed themselves to the obligation that whoever was wanted by the International Criminal Court who came to South Africa would be arrested, they didn't know that some of the culprits who were likely to be hit by that provision were sitting and past heads of state. An NGO brought an application to the High Court in order to obtain an interdict to prevent or order the executive to make sure that President al-Bashir, after he had arrived in South Africa, was not allowed to leave so that South Africa could carry out its obligations. The stance taken by the High Court was that South Africa had to honor its obligations in terms of the Rome Statute. And indeed, an order was issued by the High Court of South Africa, compelling the executive not to allow President al-Bashir to leave South Africa. But somehow, the executive allowed him to leave before the order was served. What comes out of that is that you have the High Court in South Africa taking a very principled position in line with the protection and promotion of the rule of law, that this is what South Africa had put its signature to, and there was no acceptable reason in law for it not to act in line with its obligations. A subsequent appeal to the Supreme Court of Appeal only went to confirm what the High Court had said, that South Africa had an obligation to arrest President al-Bashir. Another case is a case relating to a tribunal that had been set up by the heads of state and government of Southern Africa, referred to normally as the SAD Tribunal. This is a tribunal that had been set up to make sure that in all the countries which fell under the SADC, which had signed an agreement, there would be no human rights violations. However, when in Zimbabwe, certain farmers' farms were seized and the courts were prevented in that country from adjudicating cases relating to those farmers. Those farmers went to this tribunal which had been set up by the heads of state and government in Southern Africa. And that tribunal gave judgment in their favor, in terms of which Zimbabwe was supposed to ensure that they got compensation. But Zimbabwe refused to comply. And what then the heads of state and government in Southern Africa did, including South Africa, was to begin to render the tribunal dysfunctional, so that ultimately it could not enforce its own order to assist these farmers. And that they did by making sure that vacancies on the bench were not filled and other important personnel so that the tribunal could simply not work. South Africa was party to those protocols which sought to render the tribunal dysfunctional. But some of the farmers in Zimbabwe were South African citizens. So they then came to the courts in South Africa in order to obtain an order declaring that the president of South Africa had acted unconstitutionally by lending his approval to such measures. And the High Court and the Constitutional Court of South Africa actually found in their favor and declared that the president of South Africa had acted unconstitutionally in violation of Section 7 of the Constitution of South Africa in being party to a measure aimed at preventing access to justice, a right that is provided for in Section 34 of our Constitution. There too, you see the judiciary of South Africa standing up to be counted when people's rights were violated. The Constitutional Court itself had two cases that are very important that I want to share with you. And they relate to the commission that I chaired. And it seems to me quite important that I should share with you something about these cases because it also relates to the State Capture Commission, and the World Justice Project has taken my leadership in that commission into account in concluding that I'm deserving of this very prestigious award. When you look at the terms of reference of the State Capture Commission that I led, you would see that the then president of South Africa, Mr. Zuma, was central to the investigation that I was supposed to conduct into allegations of state capture and corruption, because there was a repeated reference to his role. And therefore, when the commission conducted its investigation, he had to come and answer. Indeed, many witnesses implicated him in conduct that was seen as part of the state capture. And he was called upon to come and testify. He agreed initially. He testified, he didn't finish, and then he left promising to come back. But as the commission went on and more evidence was piling up implicating him, he started putting up excuses about coming back to finish his evidence. So ultimately, I decided that he had to be issued with a summons to compel him to appear. And he came on the first day, applied for my recusal because he said he and I were friends, and he thought that as a friend I would be against him. I would be biased against him. But of course, it was not true that we were friends. We knew each other. I know many politicians, but we were not friends. I dismissed his recusal application, and when he was supposed to take the witness stand, he walked out of the commission in the full glare of TV cameras with the whole nation watching. He walked out defiantly. I had to make a decision what was to happen. Of course, this conduct by him undermined the rule of law, undermined the commission, and there was no way the commission could just allow that to happen without any consequences. The commission would have lost all credibility. It fell upon me to make a decision as the chairperson of the commission what would happen. And I decided we would approach the Constitutional Court and get an order compelling him to come back to the commission, which we did, and he didn't oppose it. And when he was supposed to comply, he also defied the highest court in the land. Now, that was something completely unheard of. He defied. He said he could not be threatened with jail. He was not scared of jail. But what was happening is that around his residence, there were large groups of supporters who were gathering, making all kinds of threats against the judiciary, against me as chairman of the commission, and saying that he should not be touched, and that if he was touched, there would be blood. So it also fell upon me to make a decision as to what we should do now that he had defied the highest court in the land. And it appeared to me that what had to be done was something that would be effective. We could have laid a complaint with the police and let them investigate. We could have gone to a lower court, but I decided what would be most effective is to go to the constitutional court, obtain a final order that could not be appealed against. And then we went to the constitutional court, the commission, and asked the commission to find him guilty of contempt of court and to send him to jail for 2 years. The constitutional court agreed that he was guilty of contempt, but it sent him to jail for 15 months. After that, the whole country was on tenterhooks because the question that arose was what was going to happen. Was this order going to be executed? Because there were these large throngs of supporters who were gathering around his residence, threatening judges, saying all kinds of things against judges, and saying nobody would touch him. He was not going to go to jail. So the law enforcement agencies were also coming close because they had to carry out their duty. What we had done as the commission is to make sure that the Minister of Police and the Minister of Justice were joined in the court proceedings, and an order was made that if the former president did not hand himself over to the jail authorities by a certain date, they, that is the Minister of Justice and the Minister of Police, had to take whatever steps were necessary to make sure that he went to jail and served his sentence. Ultimately, he handed himself over, which was good, and the whole country sighed with relief that he had handed him over. But in the process, his supporters continued to threaten the judges, insult judges of the constitutional court, insult the chairman of the commission. But throughout this period, the judges concerned stood firm and made sure that the rule of law was not threatened. In the context of the theme for this conference, I believe that when you look at the cases that I've just indicated, whether it is those that are related to Parliament shirking its responsibility, you find the judiciary of South Africa saying to Parliament, you are not doing your job. You are not carrying out your constitutional obligations. Carry out your constitutional obligations. But whether you are looking at the executive, when the executive tries to find excuses for not wanting to carry out their obligations in terms of the Rome of Statute obligations, you find the judiciary of South Africa saying, executive, you are not doing your job. You must do your job. And whether it's a situation where the judiciary of South Africa and the judges of the highest court in our country are being threatened by throngs of supporters of a powerful political leader, that there will be blood if somebody is touched, you find the judiciary of South Africa not shaking. You find them standing firm on the rule of law. And when we celebrated 30 years of the Constitutional Court on Friday, I remembered exactly those instances about our judiciary. And I think our judiciary has really stood up to make sure that South Africa continues to be a country that is based on the rule of law. Given the time available, I can't share with you many more other cases that I would have liked to share with you. But I do want to say, as I approach my conclusion, that one of the problems we had before last year's general elections was that Parliament had one party that was the majority, the ruling party that had been the ruling party from 1994. What had happened over the years was that because the majority party was led at a certain time by a president that was implicated in state capture and corruption, you found that because of our system of government, the members of parliament who supported that party or were part of that party would always protect that president whenever attempts were made during the years of state capture to unseat him, to pass a vote of no confidence. But they had the numbers. So the opposition parties tried to substantiate and bring up evidence of corruption and state capture, but in the end it didn't matter because the majority party had numbers. But from last year, no party has the majority status in parliament. It looks like to me that is a better situation for us because once every party depends on other parties, I think there is going to be more accountability. But the one thing that I fear, and I want to share that with you as I close, is the fact that the president who was found by the commission to have been part of the state capture, the capture of the state, has a party that got 14% of the votes last year. The ruling party, the ANC, got 40%. It could not make government alone. It needed other parties. If it had decided to go into a coalition with the former president's party, they would have had 54% and therefore would have been able to enjoy majority status in parliament. And that would have meant for South Africa going back to the years of state capture. I can't say it will never happen because I see in the media that there are quite a number of voices in the ruling party which say the ANC should have entered into a coalition with his party, the former president's party. So those in South Africa and outside of South Africa wish South Africa to continue as a country that is based on the rule of law must continue to help us and support us so that South Africa never goes back to state capture, because state capture is an antithesis of the rule of law. With these words, I thank the World Justice Project for making me the 2025 recipient of the Rule of Law Award. I feel honored and privileged, and I wish the World Justice Project success, and I will be here and continue to see everybody for the rest of the week. But I take this opportunity to say thank you very much.
Thank you, Chief Justice Zondo, for those inspiring remarks. And we all know in standing up for the rule of law, one's legs can grow weary. And we are so delighted that yours never seem to have ever done so. So thank you so very much. What an incredible way to close the first day of this conference and forum and remind our community assembled what the rule of law achievements can do to make a country and its people better. When there's principled leadership, I would like to also express our appreciation to the esteemed WJP board members and members of the Leadership Council who guided WJP to select the Chief Justice as the awardee. Those members are Kamal Ayadi, Cherie Blair, and Monli Makahaya. As we conclude tonight's program, allow me to take a few minutes to remind you of what's next on the agenda. This evening at 7 p.m., you are all invited to attend a powerful concert featuring Dagadana and Trupa Trupa, two groundbreaking musical acts from Poland and from the Ukraine. They will be performing at the historic Zaluski Library. And you can get your free tickets still if you go on the app for the forum or go to the website of the World Justice Project. Sometime this week, we ask all of you to take up the opportunity to go to the orange box outside this hall and to film your short video clip in response to one of the many prompts that are in the box. You'll become a part of something that's bigger and better than all of us as we collect all of these wonderful short video clips. And finally, I think tomorrow morning we will reconvene here at 9 a.m. for a very important plenary session and conversation about building resilience and justice institutions. So thank you very much to all of you. We are delighted that you are here with us, and we hope you have a good evening. Thank you.